So to resume our regularly scheduled programming from here on out, Chuck, I hear you have a hypo.
I do have a hypo. Is there a slide, or should I just do the hypo?
There is a slide.
There is a slide, okay. So I'm going to restrain myself and not call on audience members. We will, however, call on panelists. And so the hypo, basically, we thought we would do this as a sort of a hypo to sort of place some context around today's discussion. So you're the general counsel of a large global U.S. financial institution, global bank, happens to be located in Pennsylvania. It used to be Bloombergia, but discretion took over, and we changed it to Pennsylvania. Accounts for 12% of your clients' global net income. You're advised in the morning by the head of compliance in Pennsylvania that the local financial regulators received 3 or 4 anonymous tips that one or more of the global bank branches in Pennsylvania has been assisting a local criminal gang in money laundering, primarily, we think, from illegal gaming operations in Pennsylvania. And Pennsylvania does have laws that do protect whistleblowers. The money laundering likely involves transfers of funds to the United States, Germany, other foreign jurisdictions where the gang has operations. Neither the country head nor the head of compliance is actually aware of there being any money laundering violations. However, you know that to the extent there's gang involvement, the gangs in Pennsylvania are pretty violent. It's possible someone has threatened a branch manager or someone back in clearance and settlement in order to facilitate the scheme. The country head is also quite worried that if word of this leaks out, there's likely to be a PR problem. Clients will shun the company. It'll cause a substantial drop in client business, but a quick PR response will help recover anything that does get out. So what we'll do is we'll throw this open. We've got a really great panel today of folks who have been on the regulatory side, the in-house side, as well as the outside counsel side. So what we thought we would do is throw this open to the panelists with a series of questions, which we'll ask each of them to address. So first, turning to Noah, Karen, and Joe, on the in-house side, what do you do first as the in-house attorney? What issues do you anticipate, and how do you really sort of look to address these things?
Yeah. So I'll start. So whenever we have something like this, I mean, mercifully we haven't had anything quite like this, but certainly at Morgan Stanley we've had our fair share over the dozen years that I've been there. Immediately, we think about it in 2 ways. So one is, who needs to know about this? Who needs to know internally? And that can be anyone from, does the board need to know? Does the audit committee, does corporate communications need to be in the loop? Do our in-house counsel need to know about this? Up the management chain, who needs to know? And at the same time, we're immediately trying to scope out what it is, what it is that we have here, and how do we go about thinking about ascertaining whether or not it's true, whether it's not true. In this hypothetical, because the whistleblower has already gone to the regulator, some of the questions we often wrestle with later, when to self-report, that's already been taken out of the equation, but certainly we're going to, and I think we'll probably talk about it later, we will have self-reporting discussions or decisions to make, given the sort of multi-jurisdictional nature of the allegations. Do we have obligations to report to regulators in different jurisdictions? When will we do that? We're starting to think about that from minute one, realizing that we do have a short time clock. We're on notice as of this particular day. And while most regulators will give us a little bit of time to get our act together, that time is not indefinite.
Great.
I'm sorry, Karen.
No, sure, I can pick up from there. So I would just emphasize, because in this case you already understand that the local regulator has been informed, you're already sort of behind the game, right? So you need to do everything you can very quickly to get your arms around what the relevant facts are, and then as the case develops, think about whether there's additional reporting that you have to do outside the relevant or outside the local jurisdiction. But it's really basics, right? So beginning of any investigation, who, what, where, what's your plan? And that's, the scope of the review, who do you need to talk to, which people might be relevant, documents need to be pulled. You have to really think about, given that there's a cross-jurisdictional element here, you have to think about very carefully your document collection and review protocols, in particular, given the developments around data privacy in Europe. That's going to be very critical in making sure you've thought that through from the outset and involved vendors, if needed, to help assist with that. Obviously, preservation, retention, these are all the standard things that you would do. Noah referred to who needs to know. So that's obviously an element of any case, but also who shouldn't know, right? So given the fact that you might have, you could have some influence, external influence on the people involved, I would suggest in a case like this, you'd want to keep the circle very, very limited and reassess that as you develop the facts. There may be, depending on whether there's senior involvement or awareness, you might want to consider things like whether you need a special committee of the board. We're sort of, the facts here are very kind of basic for obvious reasons, but those are the kinds of things you'd want to think about as you moved ahead.
Yeah, I would say the self-reporting question is sort of interesting here because the local regulator presumably is the regulator in Pennsylvania, which is 12% of your revenue, but probably not your prudential regulator in this context. So that person already knows. So I do think a person of authority who's going to be the sort of front person in terms of communicating with the regulator in Pennsylvania will absolutely need to get back to him and say, look, we're starting this investigation. We will report back as we know more. It does beg the question whether, in a macro sense, whether you would immediately pick up the phone and call the Fed or the OCC or the DFS if you were in the U.S. and regulated there now, as opposed to wait until you have more information. I think it's a very nuanced situation. So it may be you'd wait. It may be if there are regular communications with this person in Pennsylvania, you'd bite the bullet sooner. Ideally, you'd like to know a little bit more. And then just from a legal and compliance perspective and how the thing gets actually handled, there are pretty substantial differences, I think, still among the large financial players in terms of who actually would run an investigation like this internally. I don't think I'd instinctively pick up the phone and call an outside lawyer just yet. I want to do some forensic analysis around money movements, isolating the branch, finding out who the large clients are, and trying to sort of solve the puzzle through data even before you necessarily talk to too many people. But in a number of institutions, particularly some of the European institutions and the one that I was last at before going to the vendor side, there are investigatory units that sort of sit apart from legal, if you will, that are sort of imbued with both lawyers and forensic accountant types. And they sometimes get more directly involved with some assistance from the lawyers in terms of actually running with the investigation. Slightly different model, I think, for the American banks. But certainly in the European context, to some extent, lawyers are somewhat disfavored relative to forensic accountants, at least in my experience. So,
I mean, it may be personal bias, but I think one of the first questions that you have to answer is what are the privilege rules
right.
in the potentially relevant jurisdictions?
Right.
Because I would advise against embarking upon an investigation using one structure that may ultimately turn out not to be protected by privilege, depending on who's running with it. Right?
I consistently advise that way.
So you've got Germany implicated. They've got
right.
Very different privilege rules than we have in the U.S. It's pretty clear there's no in-house privilege. So that given the nexus there, this may be a case where you would want to get external counsel involved relatively quickly. But that's a really key question that I think needs to be answered right up front.
So clearly this is just a hypothetical. Not that it draws upon any of my experience as an in-house person, but there are jurisdictions I should mention as well where if you have something like Yakuza or local gangs, you actually have to report it to the police also. And it creates a little bit of a conflict between the financial regulator and the guys that are actually there to get the bad guys, the hard bad guys. But that's a good segue to our next question, which is how do we handle reporting in Pennsylvania, in other foreign jurisdictions? We use Germany, it could be any other jurisdiction, of course, the United States. And really in the sense of both stuff that we might uncover first, or alternatively things that, like in this scenario, have already been raised with the Pennsylvania regulators. So why don't we start with Nola on that one?
Yeah. Well, I think you have a lot of questions to think about. When do you report to a regulator? Which regulator do you report to, and what do you report to a regulator? So, when here is you have the added aspect of a potential dangerous situation, right? And I think you have to think right away about do we have employees in danger? Are there other people in danger? And that maybe should take precedence over anything else. And so, a very quick internal investigation, perhaps making contact with, trying to figure out making contact with the whistleblower, trying to figure out whether there's an employee who may actually be in danger. Then thinking about which regulators and the culture of the regulator, right? We all know that in different countries, different regulators ask different things of us. For instance, one matter in Japan where the culture there, I believe, is really to report almost the moment you learn something. One case where something was reported before even anyone inside the bank was told, and anyone illegal was told inside the bank, and actually worked out very nicely. So I think that that in Japan is one setting, but then who knows what Pennsylvania is like, or your other countries. You have to think about which regulator has which kind of preferences in terms of. In the U.S., the regulator, you might prefer a more fulsome, detailed presentation. If the danger issue is off the table, maybe you want to do a little bit more digging before you go and you make that report. And then also you have to think about, from the regulator side, leaks, right? There's the issue of publicity here in this hypothetical. So, there's some regulators that you might view as ironclad, and they're going to have discretion, and they're going to work with you to get this situation under control. And there's others that you might worry that, in a few days, the whole matter might end up splashed all over the internet. So, which and when are two really important questions. And then in terms of what you report, I think really depends on how your internal investigation goes, and here we don't know yet how it proceeds. But I think at least when you're dealing with the U.S. regulators, they tend to prefer a full presentation, if possible, if there's time to do that before really reporting is warranted.
Thank you. Julie?
Great. So in terms of when you're actually self-reporting, I think it's important to keep in mind that you're providing the good and bad facts. There might be some tendency to leave out gloss over the bad facts, but in my view, you're sort of defeating the purpose of a self-report if you're just not being honest and straightforward with the regulator. What you're trying to do is build a relationship with that regulator, which is going to last for a long time. You want to have credibility, and you don't want to lose, the point of a self-report by not giving them the relevant facts. And then at the appropriate time, I think you should be considering, providing them with a plan of action. You don't want to leave them with the impression that, okay, you have this issue, nothing's going to be done about it. You want to show that you're going to be proactive, and you want to sort of get their buy-in. I think it's in your interest to develop a collaborative plan to the extent possible. I know in an earlier panel we talked about the SFO and how that's not always feasible, but to the extent it is, I think that's an important thing to do.
I would just add sort of dovetailing off that, what Julie just said, there is a middle ground, which we've often used, which is, you haven't done the fulsome report yet, but you put a placeholder in with your prudential regulator, your on-site regulator, heads up, this has happened, we'll get back to you in 2 weeks, give us time. And so you're on record having notified them. Of course, the danger there is, once you can't unring the bell. Once you tell your regulator, that's it, and they're going to expect to hear from you in a couple of weeks. But certainly, again, in this scenario, that's something that we would likely do.
I think another point to keep in mind once you start reporting to less so the regulators, but more other authorities, criminal enforcers, particularly outside the U.S., is to make sure you've refreshed the Dawn Raid training for these branches. I think we can't underestimate the importance of making sure that people on the ground are prepared to respond when the police show up and start asking for documents. It's something that's sometimes overlooked. So.
Yeah, I would draw a sharp distinction between the internal prudential regulators and say, the U.S. Attorney's Office or the SEC or whoever would be the relevant ultimate enforcement authority here. In my experience, sooner rather than later is certainly better with the internal people, particularly if you know this is going to be a problem that's going to have some visibility and at the end of the day potentially result in either a criminal sanction or a fine or something that's going to be reported and will place the firm in that kind of situation. I mean, I think at a senior level in-house, the prudential senior people are interfacing with the GCs or the heads of compliance on, if not a daily basis, certainly a bi-weekly basis. And to not report something sooner rather than later, I think runs the risk of them being somewhat annoyed at you down the road. I do, conversely, however, think that with respect to the Justice Department, and the fellow from the Justice Department on the prior panel basically made this point. He said, just don't pick up the phone and call us every time there's a whiff of a problem. They want a little bit more meat on the bones, if you will. And I would certainly wait until you know a little bit more about the underlying facts before making that call.
Can I just ask? I mean, I think many people have the experience of dealing with a non-U.S. regulator that, for whatever reason, local turf, pressures from the local industry, maybe a little bit more hostile than what you'd expect to see in the United States. Does that influence the way in which you go about talking to the local regulators?
Well, so you may have, even with the U.S. Bank, a panoply of sort of senior regulators on the prudential side. I mean, most big U.S. banks have very big operations in the UK, for example. You would be dealing with the Swiss, for sure. And so, and those regulators on the prudential side talk to each other. Mm-hmm. They meet, and they talk specifically about your institution. So, in my experience, at least with respect to that, so those sort of super regulators for you, your key prudential folks, if you're going to tell one, you might as well tell the others, because they're going to talk to each other, and there's, again, the potential that one of them will be annoyed if you haven't spoken to them.
In this hypothetical, they may already have spoken to each other, right?
They may have, although it sounds like the call went to the Pennsylvania regulator, who is maybe down the food chain.
Right.
Which, so
we don't know.
G12 country, big country, maybe calls up the German regulator.
Okay.
Who knows?
But not German.
Yeah, right.
I mean, it's someone less than German.
That's right.
Okay.
Anyone else? No? So let's switch over. The prior panel talked a little bit more about technology. So let's pivot over to technology, and really we sort of want to think a little bit about the role of technology, both from outside the firm but also within the firm, in detecting these kinds of activities, tracking them down if undetected, monitoring against them, and so forth. And so what I thought I'd do is start first a little bit with Nola, drawing on her regulatory background, really to give a sense of what the regulators might look at. We saw some of this in the prior panel, and then kick over and look at it from an in-house perspective.
Right. Well, at the U.S. Attorney's Office, actually somewhat relevant to this this panel, I ran our gangs unit, so I have some relevant experience. But this speaks to if the bank is really involved in a serious criminal situation, it might be better to pair up with a criminal regulator to actually have them take over the investigation. And what tools might they use? I mean, of course, the tools get more sophisticated every day, but now law enforcement has the benefit of triggerfish, which can target individuals through their cell phones within a matter of feet. They can do Title III applications on Snapchat, or of course your regular cellular devices. They can do roving wiretaps. They can do complicated surveillance operations. And maybe this is a situation that would be serious enough that it might be warranted to just simply turn over a portion of the investigation to criminal authorities. But then, of course, there's also monitoring of the actual money laundering transactions that are going on. And so there's going to be a whole paper side of the investigation that's going to come into play as well. And then, of course, it might be helpful to have the benefit of subpoena power to go after whatever records and combine whatever records need to be looked at to trace the money and see where it's going. And so, from the financial side, from the regulatory side, certainly there'd be a huge array of resources available. And perhaps that's the way a bank would want to go in this situation, and wear the white hat and to say, it's very clear to us that there's some involvement in criminal activity, and get an ILA for the employees that might be involved, and let the criminal regulators take over the investigation.
Have you, I know
Please.
I'm not supposed to be asking questions, but have you had experience
can't
with
ask
that
him
where...
questions.
You can't ask me questions. Anyone else questions, just not the moderator.
How has that Has that, or how has that affected the cooperation of employees at the company if you're essentially kind of acting in partnership or as another arm of a regulator?
If the institution is?
Yeah.
I think the interests start differing, right? And the individuals start really distancing themselves from the institution. Now, of course, the issue of indemnity can make things a little more interesting. It may preserve a little bit of loyalty on the individual's part, but if the bank is wearing the white hat and working with the criminal regulators, then the individuals may be left somewhat out to dry, and that may be, unfortunately, their problem, given that they've involved themselves in a criminal enterprise.
So, and Nola, so I assume you're talking about having the Justice Department take the thing over, but since the activity occurred in Pennsylvania, doesn't that complicate things a little bit?
Absolutely, right? And the Justice Department, I guess, in this hypothetical, really would only be able to look at the money laundering side of it. I'm kind of assuming maybe the Pennsylvania has access to sophisticated investigative resources, but perhaps not. Perhaps not. But yeah, the Justice Department probably, subpoena power obviously doesn't reach overseas, and so if there are U.S. entities involved, and certainly the recipients, it seems like in the hypothetical, but as we see, there's increasing partnerships. There's someone from the frauds unit who's, I think, housed within the FCA right now. And so you never know if maybe there's someone from the Justice Department in the Pennsylvania Regulatory Authority. But yeah, in the absence of a cross-border collaboration, the U.S. regulators might not, in this hypothetical, be able to do that much other than subpoena U.S. entities involved in the money laundering.
So in terms of technology and sort of the interrelationship between regulators, this dates me. I've been an academic now for 10 years, but when I was doing this, there was a fair amount of turf protection, and this sense that if you're going to go ahead and put into place tech that's going to monitor these sorts of things, we want it here. We don't want you to rely upon the Singapore hub office or the such and such office. We really are looking to have it within our jurisdictional turf. And it plays a little bit into what you're describing. Is that still an issue? Do folks get worried about, as a regulatory matter, about the effect of a global infrastructure in trying to monitor compliance with local requirements or local, in this case, problems?
Yeah. So I'll take that. I mean, it definitely is. There's certain information, for example, if it's going to lead to a SAR filing, there is going to be an expectation that material is kept domestic, and so where it's reviewed also needs to be domestic. Let me actually just, if I can step back just on the tech side just for 2 minutes. I run anti-money laundering financial crimes, and my counterparts at many of my peers have similar backgrounds. We came from prosecutors' offices. Because that's sort of traditionally what you do. You take a former prosecutor and you put them in charge of financial crimes. But the reality is that while I've learned the skill set over time, the skill set needed to run these programs is really much more operational in tech than it is chasing bad guys. We literally run millions and millions of wires through our systems, countless operational activities. We've got 450 people globally, and of course we're tiny compared to some of the money center banks. In terms of the operation that they're running. And in large respects, it is a tech operation. So we have our transaction monitoring system, negative news, a risk ranking engine. We have something called single client view, which amasses all the data globally for every client at any touch point in the firm. And all of these systems are prone to, are they designed appropriately? Are they subject to human error, and either maliciously or not maliciously? Are they not designed properly? Do we have the wrong scenarios, wrong topologies? So whenever we sort of think about tech and what can go wrong, I think about those questions. And in this case, we would use tech, but we'd also want to sort of vet it very quickly. In this case, were alerts generated that somebody missed because they were poorly trained, or did they miss them intentionally? Did the alerts not register because the scenario was designed inappropriately? Or was the scenario designed appropriately, but the alerts that missed were within the tolerance? We're not going to solve for zero. So all of those questions we're going to want to ask. Not just in this game, but we ask these questions all the time. So.
I the regulator might also be relying heavily on everything that the bank is doing internally, because the tools that you have are so much more powerful than the tools the regulator may have in terms of analyzing your own data, of course.
Yeah, I think that's absolutely the case. I mean, to Noah's point of forensic analysis of the accounts, let's assume Pennsylvania is operating under a branch of the bank in that jurisdiction. Who are the largest clients there? Drilling down there, trying to detect patterns of money transfers in with respect to that. I'd go back and look at compliance and audit reports of the branch to see if there's anything that had been flagged or at least commented on in the recent past that suggested where the activity might be somewhat squishy. And then in terms of the actual more traditional types of communications that sometimes form the bedrock of a lot of prosecutions, you sort of have to assume that probably normal email wasn't even used here. I mean, if this is a real criminal enterprise, communication channels are probably somewhat different. They probably involve personal cell phones, so on and so forth. So gathering that information and ultimately putting it onto an e-discovery platform so that someone like Quislex could then review it becomes a challenge, because you're going to need to think very, very broadly in terms of how the communications may have been conducted between the criminals and let's say the tainted person who's sitting in your organization still.
Well, and how to collect that information from people you may not necessarily want to involve, or inform so early in the investigation.
Right.
Not to mention, employment laws in Pennsylvania or Germany.
Right. Which are huge impediments, right?
Yeah, restrict your ability to actually gather that information.
Absolutely.
So in terms of going forward, the prior panel was talking a lot about big data, AI. Is this the wave of the future for these sorts of detection issues, both in terms of identifying these things before they happen, potentially also then bringing in tools that can help unwind what occurred? Is that perhaps part of the wave of the future?
Well, all the vendors say it's the wave of the future.
All the vendors do.
All the vendors do. I mean, AI in our space, I hear about it all the time, and we certainly take those meetings, but so far, a lot of it appears to me to be really just glorified macros. We're going to consolidate all these steps, and it's going to be a more efficient process, which is certainly valuable, so I don't turn my nose up at that. And certainly you hear promising things, but in terms of implementation in the next sort of 6 to 18 months, nobody's yet come to me and shown me something that's going to be smarter than our typical sort of model scenario, sort of, if X and Y, and then we'll get an alert, which granted can be crude instruments, but people are saying it's the future. AI.
Yeah, I tend to agree with Noah. We're not a technology vendor. While it's helpful in sort of scaling and potentially targeting areas for review, it's certainly not a complete cure at all in terms of how you actually get to the nub of what precisely occurred here. There's still an element of human intervention that's indispensable.
I've seen some interesting things about around looking at, I know maybe in this case we're not going to have a lot of emails, but sort of analyzing the patterns of communication between people. Mm-hmm. They could do that with phone calls as well, right? Yeah. So if there's that sort of thing I think is very useful.
Yeah, it boils it down for sure, but it's not going to spit out the exact 10 documents you're going to need necessarily.
And to what extent are there norms developing as to sort of what best practices might be in the area that a local regulator might either adopt themselves or expect a global firm to be adopting, or is it too early for that? In terms of the use of AI, the use of big data, in other words, to the extent that I adopt a particular approach, is that an approach that would be accepted by XYZ regulator who may have a different view as to what the appropriate?
I would defer to Julie and Nola, but I would say that the courts, particularly at the magistrate level, are getting more and more comfortable with sophisticated discovery protocols that kind of pass muster. It's the rare case where a court will say, yeah, I know you did all this planning around how you were going to approach the document search, but the courts are going to say it was inadequate. Review everything. I mean, that ship is kind of passed, I think.
I think
But
so.
you're
I don't-
both in
yeah.
that in that world. So.
Yeah, I don't think there's one uniform standard that, globally, certainly not, and certainly not even in the US amongst the various regulators. I think the key to whatever technology you're using, predictive analysis and the emails, is really just disclosure to your regulators, so there's absolutely no misunderstanding on their end in terms of the scope of your investigation and what you're actually doing.
I agree with that.
So let's pivot to our next question, and that's really, when do we want to bring in outside counsel? Right, we've talked about the in-house approach, a little bit about the regulators, the use of tech. At some point, you're going to bring in outside advisors, either outside counsel, maybe they are auditors, others. At what point do we bring them in? And when you are the outside counsel, what do you look at first when you're brought inside? Why don't we start with Julie on this?
Great. So there's a host of considerations in terms of when you should bring in outside counsel, including sort of the severity of the alleged wrongdoing, pervasiveness, its complexity, whether there's allegations senior members of management have been involved, or in this case, in our hypothetical, where there's a significant risk of reputational damage and or serious regulatory action. And as we've already noted, one consideration in a multi-jurisdictional investigation such as this one is privilege. We know Pennsylvania, I'm not sure the state of its law on communications with in-house counsel, but I know Germany, there's sort of limited protection. And so, as the panel already noted, generally speaking, you're trying to preserve that privilege, and I think you're best suited to do that in a multi-jurisdictional investigation such as this one when you do have outside counsel. And in terms of what you're looking at when you're brought in as outside counsel, there's just a host of things that we've already touched upon. I mean, first, figuring out the data landscape. Today it's not just emails, it's the chat rooms, it's the emails, it's the IMs. It's complicated by the employment laws and the jurisdictions that's involved, particularly where the employees bring their own devices in, and you need those devices. So you're consulting with Pennsylvania and German counsel in terms of your ability to get that. But you want to get an overview of the data landscape to make sure you're doing whatever you can at the outset to preserve the relevant data. Another thing you're trying to do is get an overview of the legal landscape for some of the reasons we already talked about. You want to make sure in your internal investigation you're complying with all the relevant data and privacy rules in the jurisdictions involved. You want to make sure that, we've already talked about this, all the internal stakeholders, the relevant internal stakeholders have been notified. There's already a risk of a leak to the press. You really don't want your board or CEO reading about this in the newspaper. And so those are just some of the things.
Yeah, I think that one thing, it's self-serving, but I would say in a matter like this, you would want to have external counsel right away, like the second that you heard about it, for a lot of reasons. One thing, I think it can be comforting for an institution to bring in outside advisors who are trained in responding to these things, who can give you the full resources of a law firm, teams of associates, and just sort of make you feel a little bit better as you take a deep breath. So that would be the first thing. And secondly, in terms of, in the hypo, there's already been, so we know the regulator already knows, you could look for particular counsel as a good relationship with that regulator. And I think that that's really can't be underestimated. Someone who maybe, recently came from that regulator or supervised someone who is now at that regulator and who could, place a call maybe to the head of enforcement or that person's deputy, who, so that immediately the bank could be at the highest levels of the regulator and coordinating and explaining the discretion that needs to be exercised and the way that the bank would like to approach it. And that's something that the right outside counsel can really provide you in a sensitive matter like this.
So let me pivot a little bit off of that. So what then, from the in-house perspective, because we touched on this really sort of early on, when do you trigger the need to bring in outside counsel? We had talked about doing some investigation, getting a better sense of the facts, doing our own review, and at some point you bring in outside counsel. From an in-house perspective, when do you think that takes place?
Yeah, we definitely do a little work first. I mean, Nola's description of teams of associates, I'm seeing dollar signs.
Really.
So, and look, Morgan Stanley, we've got over 1,600 people in our legal and compliance division, and we have a dedicated special investigations unit stocked by former AUSAs, ADAs. I mean, we've got the capacity to do it. All that being said, I agree with what Nola said. There is nothing that clarifies the mind like having, Cahill or Sullivan come in and talk to senior management in a way that is as respectful as they are of the in-house people, outside counsel. There is this mentality sometimes in-house that you get what you pay for. And if we're bringing in outside counsel, that signifies how serious this is. But certainly, we're not going to pick up the phone day one. I can't imagine. I can't recall a situation when we do. We're going to do some work. It might not be weeks and weeks. It might be a couple of days to judge how severe it is. But given this scenario, in fairly short order, we are picking up the phone.
Yeah, particularly on these facts. I mean, we just don't know anything. And outside counsel is certainly not going to be able to figure it out unless they have the in-house players really guiding them along the way. So I would say minimum a few days before you make that decision. And if you're making some progress and actually beginning to unravel the puzzle, if you will, you really want to get it to them at a point where, all right, now the real investigation begins. We're going to need to think through the regulatory communications, our ability to talk to witnesses or not, and then you're really going to need the team, if you will, of Cahill or Sullivan coming in to assist in that regard. And frankly, probably more than one team, because unless they're registered in Pennsylvania,
Yes.
you're gonna probably need multiple lawyers to assist in that process.
I agree completely with Noah and Joe with the caveat, and I keep banging the privilege drum, but yes, you want to do preparatory work in-house, but you still want to do it in a way that you can maximize your privilege protections down the road. So that just requires some careful thought. It's not impossible, obviously, and it depends where you are and where the work is being done, but it's something that has to be thought about.
To what extent, and this really speaks to your sort of practical experience in dealing with different regulators, to what extent does bringing in outside counsel get viewed as a positive or potentially even a negative? The sense that, well, you couldn't police it yourselves, and you're bringing in outside counsel, but we know who pays them.
I think that, especially when you have a whistleblower, it's helpful to bring in outside counsel just to show, we're taking this really seriously. Maybe there's some problem inside our organization, and so we're going outside our organization. We're hiring a respected institution to look into it for us, and so I think generally regulators look favorably, especially in a hypo like this, where the allegations are quite serious. I think regulators would look on it in a positive way.
I generally agree with that. I think it also just depends on the regulator. Can't speak for Pennsylvania, but even if you have an outside counsel doing the work in the background, which may be necessary given the size of the complexity of the case, you may not want outside counsel to be the interface with the regulator. It's just there are certain regulators that are, particularly sensitive about wanting to, be interacting with the face of the institution rather than outside counsel. Yeah,
I would say particularly the European prudential regulators, sending your outside lawyer in there is probably not. They wouldn't know how to deal with it. And they really want to hear from their normal context on that. So
is it fair to say the right balance is you maybe start doing this internally, you bring in outside counsel as necessary, but in certain jurisdictions, even where you've brought in outside counsel, the face to the regulator will be someone who comes from the in-house department?
I mean, frankly, even, look, serious U.S. matters, I mean, either yourself, either the GC or the head of litigation regulatory is going to be in the room.
Yeah.
And depending on the nature of the relationship, might wind up doing a lot of the talking in the room. It varies from institution to institution, but certainly I would assume I would be there if this were really serious.
Mm-hmm, mm-hmm. Yeah, I think it's not uncommon, even with banking regulators in the United States, to have the internal person being the spokesperson.
Right.
You might be at the meeting with them, but you want to show the seriousness of what's happening, particularly depending on the circumstances of the institution. If they're under consent order or DPA, et cetera.
I can recall an early encounter with the DFS on a potentially serious matter where I brought our outside counsel around because I thought there were some facts that I might not know. And at the end of the meeting, the lawyer said, "You're not getting paid enough to deal with these people on a regular basis." I'm outside now. I can say all this. I'm unconstrained.
So one of the facts in this was that it's a fairly sizable part of the business. That once word leaks out, or if word leaks out, they will lose a sizable amount of business. To what extent does that play into the way you go about the investigation, the way you interact with the regulators, even the selection of outside counsel or not? Does that play into this at all?
So it's not a huge factor, I got to say, in that we operate as if everything's going to be leaked. And without commenting on the truth of things that were just leaked about us last week, it will happen. And so you have to guide yourself accordingly. You take precautions to minimize that. And certainly to some of the earlier points that have been made here, you need to get ahead of, at least internally, of any leak. So that to the point about making sure that the relevant folks know on your audit committee, if it's appropriate, or in management, because it's a bad look to be flat-footed with people in the business reading about something in the paper, even if it's not true, and you confront that as well.
Well, it might affect the timing of your self-report now, when you know there's sort of an imminent risk of a leak. I think that sort of tends to make you report a little bit sooner.
Well, practically speaking, right, you line up your comms team, make sure that they're prepared to respond to any press inquiries, but also in terms of internal communications, making sure there's some talking points that you could use with the field or the branches if it comes to that. I mean, just early preparation.
Yeah, and clearly, if this is potentially a large hit to revenue, let's say in Pennsylvania, this account was 70% of the, and that might have been a red flag in and of itself, but it's certainly going to attract the interest of a number of senior business people to know that that will just put pressure on you as the sort of senior person managing the investigation to communicate as effectively as you can internally through the process. But there'll be no lack of sort of business interest if there's a big revenue hit potentially.
Great. So that's a really great point for me to cut in with at least one question from the audience. We have a question here about exposure for in-house counsel in a situation where the counsel first realizes in the middle of the crisis that there has been inadequate controls in some area, for instance, to protect and preserve documents. What does the in-house counsel do, right? Crisis happens, dealing with it, you brought in PR, you've talking points, and you realize that something just dropped, other than cry.
Call Julie or Nola.
Escalate.
Call Julie or Nola.
I mean, I think you have to make everybody aware of the issue. These things do not get better with time. So, one consideration is, bringing in a forensic team and to see what can be recovered. And, their ability to recover data every day goes by, it decreases. So, I think the biggest thing is to escalate and make it known to everybody working in the group so we can make sure that everything that can be done to recover any lost data is being done.
The bigger challenge is less spoliation and more discovering a year or two down the road that there's a whole other data source that you should have seen earlier, particularly with respect to huge multinational organizations. The systems challenges are every year become more complex because there are so many different ways of communicating, and that's where I think outside counsel and people like Noah and Karen you really earn your stripes to the extent you can get control over that process within your organizations.
So for the GCs in the room who are thinking, what's going to happen to me when I discover that this has happened in a crisis I'm in? There are probably no words of comfort, but what is the exposure level for an individual GC or compliance officer?
If it was unintentional,
Sure.
It's hard to see. I think another issue is, not just telling people within your team working on it, but the regulator being upfront. This is what happened. You don't want them learning about it, a year from now.
Yeah, I would say whenever the SEC has gone after general counsel historically, starting with the Sullivan situation 30 years ago and continuing, there was always a pretty bad amount of conduct involved, and to the extent that you can hold your head up that the process was in place, and maybe if there was a miss here or there, that at the end of the day, the judgment and the wisdom of the regulators would prevail, and you wouldn't necessarily be on the chopping block.
It's another reason why kind of to being very upfront and transparent with the regulators about what, how you're approaching an investigation. So we have hired Sullivan and Cromwell, we've hired Cahill, we're reviewing, 5 million pages of emails, we're speaking to 150 people and just being very transparent with them about what you're doing, obviously without waiving your work product. I think that sets you up for down the road if there's a mistake. You've demonstrated yourself as an institution who is willing to do what it takes and expend the resources that are needed in order to get to the bottom of the problem.
If I can, again, there may not be an answer to this, but a related point. Regulators, in my experience, were always very nervous about having data sets and information and reporting systems that were not physically within their jurisdiction. And so to the extent that you've got a global system where the missing data may be in something that was a system or a process that was picked up in London, let's say, and we're in Pennsylvania, you find yourself in this weird situation where on the one hand, yes, you want to fully disclose, and you really have to fully disclose. On the other hand, you're going to get beaten over the head for doing this because it would be viewed by the local regulator as something outside their control. Is there a way to balance this? And again, the answer may be simply no. Or is there some way to potentially sort of try to harmonize the global nature of the practice on the one hand and the local concerns of a regulator on the other?
Yeah, I think the answer is no.
Yeah.
You manage it, and you make the arguments when it comes up as to why this is this is more efficient overall, even though here it might be a problem. But if you guys have answers for me.
Well, plus, I agree, and the answer is no. However, post Dodd-Frank, there's this sort of movement towards ring fencing operations, because the regulators it's all about resolution of the bank in the event of a real problem, and so I do think there's a heightened regulatory expectation that everything that should affect my jurisdiction I should be able to get my hands on as a regulator, because you're operating here. And to the extent that it's not the case, I agree. There's a frustration level that can sometimes occur, particularly when you overlay data privacy and everything else. Then it really can get somewhat frustrating.
Does the ubiquity of technology help or hurt this problem? Meaning that, on the one hand, it should help because it should make access and transparency easier. On the other hand, perhaps hurt because it means it's now easier to collect the data in a jurisdiction that's outside the jurisdiction that you're in. Is there a sense of where this is going, or again, are we looking too far into the future?
Well, it's one of the reasons I'm happy not to be the big multinational bank anymore. No, yeah, it's a good question. I think I could see the frustration building as technology theoretically becomes more and more powerful. But I haven't talked to anyone at the Fed or the BaFin in the last few years.
No, look, it remains, it's one of these, no good deed goes unpunished. You put a system in place that doesn't work perfectly, you get sort of whacked for having a system even if you weren't required to do it. And when I say whacked, I'm overstating it, but you're subject to some criticism, both internally from our audit folks and externally. And the sort of tension is, when do you wait to roll it out? Until it's perfect, you'll never roll anything out. It's a challenge.
Yeah. And the DOJ is on record of saying, if there's applicable data privacy rules that are supposedly preventing you from sharing information on a U.S. investigation, they're saying the burden is on the company to justify that, and they expect you to try to find a workaround.
Well, thank you very much to our panelists, and thank you, Chuck, for taking us back to law school with the hypo.